Good morning, good afternoon. Welcome to Digital Dragons Conference. My name is Lena Marcinoska-Boulangé, and on the other side of the globe, my colleague.
Hi, my name is Monika Gorska.
Hi, Monika. Hi, everyone. Thanks for coming. Nice to meet you at this speech. And at this brief lecture, we would like to tell you something about do's and don'ts of licensing agreements. We would like to highlight very basic issues and also provide you some common mistakes and useful tips. We hope so. So please don't hesitate to ask any questions. We are available and we'll be answering Q&A and chat. So we will do our best to do it. And let's start with the topic.
Yes, so the first question is, what do these games have in common? If you know, share your knowledge with us. And if you don't, let me tell you that all those games are licensing IP, either licensing in or licensing out. The question is that probably you can come across, do you need a licensing contract? Do you need to sign a license? Probably not in every case. You don't need a licensing contract. You're probably capable of creating and developing your game on your own. You can, write software. You can write music. You can prepare graphics or designs, and you can do it on your own. But a game is a very complicated work, and in most cases you will need a license, and you will probably come across a license.
Exactly, you will bump into license, and you will have to have in mind two perspectives. As Monika said, sometimes you will need to license something into your game, for example, a software, music, a graphic. Or, for example, you would need to, or you would like to do a game that is based on some music or TV movie, and then you will need to have a license to use universe and to use characters and so on. But the other perspective is that sometimes you will have to, or you would like to, license your game out. So, for example, you are dealing with publisher, and part of a publisher agreement is, of course, a license in which you are giving a publisher a license to use your game. And another example is that you, for example, would like another entity to use some assets that you've got in your game, and let's say put them into t-shirts or caps, and then you will also need to give license out. Very important and basic thing. What is the difference between a license and an assignment? By a license, IP owner authorizes other person to use IP, and the IP owner still remains IP owner. So the licensor still have a control over IP, whereas in assignment contracts, the assignor, so the person who got an IP, sells this IP. So this person is no longer IP owner and lose the control over IP. So do not mix and mislead these terms. Is very important. And in this talk, we will discuss only licensing agreements.
Exactly. And so what is a license and how is a license concluded? A license could be a very long and complicated contract, but it could be also a very simple, straightforward contract. And also you come across a licensing agreement when you are, for example, using items or IP that is available under Creative Commons, or you are using a software that is made available under open source. Both Creative Commons and open source communities have licensing agreements, and you should really read those terms and conditions. You should analyze them, and you should check whether you are allowed to use the licensed IP in commercial works, or maybe you are only allowed to use it in non-commercial works. With regard to open source, you are probably very well aware that open source can be tainted with copyleft provisions or other provisions that limit or restrict distribution and derivative works made on the basis of a software made available under open source terms and conditions. So please always read terms and conditions of any shop, any stock, any platform that you are downloading IP works from.
Exactly, because you are taking those licenses as they are, but there are also situations in which you can, or at least theoretically, you can negotiate the license. So most probably you will have a chance to negotiate with a publisher, or for example with a brand which would like to put a in-game advertising into your game. So these are the situations that give you some chance to negotiate, and all the issues that we will touch during this presentation are theoretically issues that you can negotiate during the talk with your partner. Okay, but what's with the form of the license? It's not so easy, but because the form could vary, and it depends on a few things. First, it depends on the governing law, and the second, most likely, it could depend on the subject of the agreement. And the example is Poland. For some subjects, for example, in Copyright Act, you can sign a license in one form, but the other act, which is about trademarks and patents, requires another form. So in general, if you've got your license in writing, by which we understand wet ink signature, most probably it will be binding and valid in most of countries. So this is not a problematic form, but there are also the other forms.
Yes, and apart from a wet ink signature, you can have electronic signature. And here you have to distinguish between a qualified electronic signature and other electronic signatures. And it is very important to check the governing law, as Lena said, because in some jurisdictions, only a qualified electronic signature is equivalent to a written signature, meaning a wet ink signature. And the governing law may require that a license is signed either in wet ink or with qualified electronic signature. So you have to check that. Other electronic signature, we've just put some examples, but again, you have to check with the contracting party, you have to check the governing law, because sometimes it can turn out that a DocuSign signature will not be enough for a contract to be binding. And the third form of, let's call it an electronic signature, is when you are downloading licensed IP from a platform, from a stock of photos, where you just click on terms and conditions. That could be enough, and the license is concluded, and the license is binding for both parties. So not in every case you need a signature. Sometimes a tick or a click is enough for a contract to be formed.
Yes, and in some cases it will be even enough to have just oral license. So for example, I can say that I authorized Monica to use my painting that I painted yesterday, but the problem is that Monica and I will need to evidence that fact and evidence all essential provisions of the license. So it could be problematic, and also it could be problematic if another party, for example, a party with whom Monica is cooperating, would like to be sure that Monica got such authorization from me.
Okay, so when you are developing a game, you can be both a licensee and a licensor. So going back to what Lena said in the beginning, you can be licensing in IP from some other people, from other entities, from your contractors, or you can be licensing out your IP, your game, your assets to someone else. So this dual perspective, this dual character of a game developer is very important, because when you are negotiating, when you are signing contracts, licensing contracts, you always have, you need to have at the back of your mind that you will be both a licensee and a licensor. Whatever you are licensing in, you will be then licensing out, and those provisions should, correspond to each other, and you should work towards securing your interest in the best way. Okay, so now we would like to talk to you about provisions that you will come across in a licensing contract. Now, first few reservations. There are no two licensing contracts alike. Each contract is different because there is a different market situation, a different company. There is either a licensee or a licensor. There are different legal situations or legal factors that come into play. So there are no kind of standard provisions that apply when you sign or when you negotiate, when you discuss a licensing agreement. So that's the first reservation. And therefore, we only selected certain provisions, or certain topics that are very important when you are thinking and negotiating and drafting a licensing agreement. So please bear in mind that within a licensing agreement, you will come across many other provisions that we have not covered in our short lecture. We selected only those that we feel are the most important and that you should really pay attention to.
Exactly. So the next issue is where. So what is the territory on which you can use, on which you authorize somebody else to use your IP. You can choose it. It's up to you. You can give a license for US, for Europe, and so on. You can also choose some test markets before you are going global. But the issue is that most of IP rights are territorial. So you need to adjust what you've got with the license that, for example, you want to give to somebody. So, for example, if you've got your game title registered in EU and you are dealing with a party from, let's say, Japan, it could be problematic because you do not have a right for the territory in which somebody's probably wants to have a license. And the next thing is a choice of governing law. It's a clause that is usually at the very end of the contract. And sometimes you can choose governing law, sometimes you got some influence what governing law is chosen. But most probably, especially publisher will like to impose governing law on you. So of course, the best situation is that the governing law is the law that is the closest to you, or the law that you do know, but most probably it's not possible. So in those situations, make sure that everything is included in the license, that the license is very precise, because otherwise this governing law that is chosen at the very end of the contract will govern those issues that are not touched in the contract. And the next issue is how the IP that is a subject of the license can be exploited. So as we told you, the license is in general a contract in which you obtain or give a right to use some IP, but in general, such term is not enough. You need to set very well what are we call that fields of exploitation, whether, for example, a publisher with whom you are dealing will have a right to sell, to distribute, import, export, publish, whether a publisher, for example, if he is to make localizations of the game, whether the license provision should reflect that obligation to not to give publisher excuses, any excuses.
Yes, exactly. You should be very clear and precise, and you should try to include in the licensing contract everything that you want to regulate. So all the duties and obligations of both parties, of you as a licensor or a licensee and your contractor. You have to be very precise, and you should not leave anything out of the contract. And Lena told you about how the IP, that you should regulate how the IP is exploited, but also you should think and draft or look for provisions that restrict use of IP. And you can come across those in various contracts. And restrictions on use refer to, for example, use of licensed IP for other purposes than those set out in the contract, in the licensing contract. So, for example, imagine music. So you are licensing in music. You're getting a right to use music in your game, but for example, you forgot to regulate that that music will be used also for I don't know, an event to launch your game. Now, this could be a breach of license if you don't regulate it, or the music composer can directly state that he does not want to that he does not want his music to be used for other purposes than only the game. So that will be a restriction on use. Furthermore, look for the restrictions, or look how you can use the IP and within what content or what context. Sometimes trademark owners will limit the use of their trademarks to only a use that does not put the trademark in any negative light, or does not diminish or tarnish the trademark. That's also very important, because maybe you are thinking about using a trademark in a sort of a shooter game, and then it turns out that the trademark owner says, well, I don't want my trademark to explode, or I don't want my trademark to be applied on a uniform of someone who is being shot or killed or whatever. Another restriction on use could be whether or not you are allowed to make any alterations to the licensed IP. So can you change it? Can you modify it? Can you shorten it? Can you change colors and everything? Also, the IP holder can impose some restrictions, or you as an IP holder can impose restrictions on your licensee. So think of both those perspectives.
Exactly. And the next thing is to define term of the license. The license can be for fixed term that you can set by, for example, specifying a date, or the term, for example, 2 years, 5 years, or some specific event. And it could be for indefinite term. Be careful with perpetual licenses that are very common in US and mainly for software. In some jurisdictions under some governing law, those governing laws do not recognize the perpetual licenses, but irrespective of the term of the license, the most important thing are consequences of your selection. So Monica will tell you about the most important consequence.
Of course. So a license is for, if a license is for fixed term, then it ends on the lapse of that term. If a license is for indefinite term, then you can have various reasons for terminations, or you can provide for various situations in which the license is to come to an end. And when thinking about the termination, think about the term of notice. So think about the period in which the contract will end. Is 1 month enough for you to finish the license, to end the license, or maybe you need some more time? Maybe 3 months, it would be enough, or maybe you need even more, 6 months or a year. It all depends on a particular situation. With regards to the term of notice, also check for auto renewals or any renewals. Sometimes a license could provide for an auto renewal of the license. So it could be for a year, and then if the parties don't terminate it within 1 month before the lapse of the license, it renews itself for another period of a year, 2 years, 3 years, or 4 years. Next, you should check and define reasons for termination. And here you can have two situations. There could be provisions concerning material breach, which allow immediate termination for either a licensee or a licensor. So these concern major infringements of terms and conditions of the license. And you can have other situations in which trigger termination. Usually those are linked to a cure period. So you get 15, 30 days to amend the situation, to amend the breach. And if you don't do it, then the license is terminated. And finally, you should regulate form of notice. So if you want to terminate the license, do you do it in writing? Do you send it by post, or is it enough to just send an email, or maybe just call someone and say, hey, I don't want this contract to be binding anymore. I am terminating this contract with 1 month notice. So think about the form of notice, because it will bind you. It will set out the rules on how you terminate the contract.
Exactly. And the next very important provision is about exclusivity. And it means if you've got an exclusive license, it means that only you can use that IP. And if you've got non-exclusive license, it means that more entities can use that IP. So non-exclusive licenses are most common, for example, in software engines. And exclusive license is something which will be probably expected by a publisher. You can also have exclusive publishers and exclusive licenses, many exclusive licenses. I mean, for example, you can deal with a publisher who is good at Japanese market, and he will have exclusive license on that market, but you can also have exclusive publishers, so give him exclusive license for other territory. But please make sure that first thing, that those licenses, exclusive license, do not intertwine. And another thing is that make sure that both parties understand exclusivity in the same way. It means that in some countries there is something that is called sole license. In Polish, we would rather include that into exclusive license. So make sure that, for example, you as a licensor, are you excluded from using this IP if you give exclusive license or not? So this is very important, and exclusivity will have a great impact on royalties. So also reconsider what you want to achieve.
Yes, and other than exclusivity and term and termination, you should also regulate channels of distribution, so platforms. What platforms your IP will be used on, or what platforms do you want to use someone else's IP. That's very important to be, again, precise and to be exhaustive, and to list all the channels of distribution that you intend to license your IP, or that you intend to get a license to use the IP. With regards to channels of distribution, you can come across a provision that is called right of first refusal, which is sometimes inserted in licensing contracts, specifically if you don't want to set out all the channels of distribution upfront in the licensing contract, and you want to leave yourself some freedom. Usually you will find such provisions in a contract with a publisher. And then right of first refusal means that a publisher is offered various channels of distribution. He is offered the right to license and to use your IP on those various channels of distribution. And if the publisher agrees, then obviously it has a certain aspect on the financial side of the contract. So the side on channels of distribution, and then you can also think of the right of first refusal.
Exactly. And the next thing is sublicense. So for example, from the perspective of licensor, you will be interested in having control over your IP. So you need to very carefully check whether you are giving a right to sublicense and together with the license. and how broad is it, whether it enables to give sub-licenses to any other entity, or only, for example, entities from the group, or only entities that are exclusively mentioned in the contract, and the same from the perspective of licensee. So when you are taking something in, make sure and then you want to use it further, make sure that you have in this license a right to give further licenses. And the next thing is derivative rights. So again, if you are a licensee, especially if you want to use something in your game, make sure that you can make some modifications, and then that you can use them further.
Yes, and you have some provisions that are called change of control or assignment. Those are two sets of provision, different provisions. So assignment of a license means that you are changing a contractor or changing a party to a licensing agreement. For example, if you are a licensor, someone else steps into a licensor, or if you are a licensee, for example, you don't want to perform this contract anymore, someone else can step into your shoes and replace you in that contract, and that's an assignment of a license. And check the provision whether or not an assignment of a license requires a consent of the other contracting party. Typically, an assignment will require a prior consent, so you have to inform the other party about possible potential assignment, and that other party must must consent to such swapping of contracting parties. A change of control provision is a provision to do with any changes with regard to shareholders or entities that are exercising control over an entity. So if you are either a licensor or a licensee, and you are a company, then usually a company has shareholders or members of the management board or any other composition. And if that composition changes, then the other party can say, well, I'm no longer interested in this contract because I only entered the contract because of your shareholder or because of that particular member of the management board. Change of control provisions usually tend to trigger termination. So they allow the other party to terminate if any change to the composition of the company happens.
Exactly.
Okay, liability. Obviously, this is a subject that's different and an individual lecture could be prepared on. With regard to liability, you can have opposing perspective, and by opposing perspective, I mean it depends on whether you are a licensor or a licensee. If you are a licensor, so you give your IP to someone else, obviously you want to either exclude your liability or limit your liability, because you are just giving away your IP. And think of software licenses. There are always provisions we are not liable for, and there's a long list of things that software licensor is not liable for. So you could also cap your liability. You could be interested in inserting such provision, and to cap a liability means that you are liable only up to a certain amount, to a certain threshold. You set the threshold, and that's the maximum liability, financial liability that you will take. And obviously, as a licensor, you could be interested in limiting your liability for direct damages. So only those damages that are somehow directly stem from whatever IP you licensed. This limitation of liability obviously has great impact on compensation, if there is any compensation to be paid. If you are a licensee, so if you are receiving IP and you're obtaining IP from someone else, obviously your attitude, your approach is totally different, because you are getting something from someone, so you want the liability to be included. You want your contractor to be fully liable for whatever IP he or she prepared. You don't want any caps, you don't want any treasures of liability, and you want them to be liable not only for damages, but also for any profit that you lose or you are likely to lose if, for example, there is an IP infringement, or if the IP is, you know, bugged, or the I don't know, graphics or software is full of bugs or problems. So think here with liability, you think of opposing perspectives there.
Exactly. And now let's get down to business and take one very particular perspective. And Monica, let's do it together. Let's take a perspective of a licensor who would like to, of course, make money on the license. There is no one perfect, ideal provision and method of calculating royalty remuneration. It can be one-off or periodical. It could be in percents, or it could be fixed amount. But rather than about numbers, we think that you should focus more about mechanisms. So think whether it is what amount is the benchmark, for example, whether it's percents of amount which is net or gross. Also reconsider whether a publisher can make, let's say, some discounts, and you have your royalties in percents, because of course it makes a big difference whether you have 2% of 100 euros and 2% of let's say 10 euros. You should also think when the royalties starts, how frequently they are calculated, whether a publisher needs to meet some targets. What if he does not meet the target? What are the consequences of that? What about interest? And most important thing, how you will check all those things. So whether you have a right to audit, check the books, and so on. Monica, anything?
Yes, exactly. So check the definitions, how the royalty is defined, and all those things that Lena just said. Check the terms, check the rules, check the timeline. Also check the currency. What currency will the royalty be paid in? Check the mode of payment. Is it a bank transfer or any other mode of payment? And also check inflation. Do you have any provisions concerning inflation or exchange rates, or any market changes that could happen? So don't only think about the numbers, think about methods and mechanism of calculating those numbers.
And now a case.
Yes. So The Witcher is a great example of a situation in which there was a license, and a license fee was paid out. We know from newspapers and from reports that Mr. Sapkowski, the creator of the Witcher books, received a remuneration many years ago when CD Projekt Red approached him with a request to license the IP, the Witcher IP. Mr. Sapkowski received a payment, but The Witcher became a global phenomenon. It became a global hit. And we all know also from newspapers and from information that CD Projekt earned quite a lot of money on The Witcher. Mr. Sapkowski then relied on a provision that is in the Copyright Act, in the Polish Copyright Act, but I think you can also find it in other jurisdiction, in other governing laws. And that provision stipulated that if there is a gross difference, a gross disproportion between a license fee that was paid out and the profit that is made by a licensee, then the author, the creator of the IP that is being licensed, can request additional payment. And that was actually the legal basis of Mr. Sepkowski's claim. We know that the case has been settled. We don't know the terms of the settlement, obviously, but The Witcher is a great example that you should maybe think of what will happen if your game becomes a success. And again, this is very important both from the perspective of a licensor and a licensee. Think upfront about a mechanism, a method of calculating this additional remuneration. What is meant by gross disproportion? Can you modify those statutory terms in any way? That depends on the governing law. Again, going back to what Lena said, that's why checking governing law is so important. And yes, think about the Witcher case as an example that you should come up with some sort of an instrument, a method, a mechanism of paying out, or maybe just providing for additional remuneration when your game and if your game becomes a success.
Exactly, and instead at the end, instead of the checklist, we prepared a very basic graph that illustrates the license agreement, of course. So you've got a licensor who gives some rights to licensee. In the licensor, both parties, but both parties need to set all those things that are at the top term, whether it's exclusive or not, scope, how to use IP, whether it's with sub-license or not. And in exchange, licensee has some mutual considerations to pay royalties and all other aspects and obligations, for example, which are very important on the publisher side.
Yes, all those things that were mentioned on the checklist are really important. And again, going back to what I said, there are no two licenses alike, and you really have to pay attention to those terms. And Alan Wake actually is a great example of the fact that even the big boys get it sometimes wrong. You might be aware of the fact that Alan Wake was withdrawn from various platforms because some music licenses expired. And please remember that if a license expires, if the license is terminated, you are no longer authorized to use that IP, or you risk liability. So with regard to Alan Wake, the game had to be pulled out from different shops and platforms, and the game was reintroduced, I think, after almost a year or after some time, definitely, when the licenses were sorted out or replaced or new licenses were negotiated and concluded.
Exactly, and the next case, we are sure that you know that case between No Doubt and Activision. So in this case, it was totally undisputed that the parties entered into some kind of contract by which members of No Doubt team consent to Activision to use their likeness in game as avatars. So there was no dispute that there was a license or some kind of consent to do that. But the problem was that the scope of that consent was unclear. So the members of No Doubt claimed that they did not accept it to use their likeness, including Gwen Stefani likeness, to sing song of other artists, but only to sing song of No Doubt. But Activision claimed something totally different, and in addition it claimed that it's obvious and confirmed by common practice that in such cases likeness is used for many songs, not only of that band. So this case was settled, but the lesson of that case is that not only having a license or consent to use some IP is important, but the thing that is really important is to make it precisely and to have the consent that is understood by the parties in the same way.
So some general don'ts to conclude our presentation. Do not rely on templates, specifically templates taken from internet. those templates are usually very basic, not always correct, and not always securing your interests in the best way. It's really risky to rely only on templates. It's better to negotiate a contract or to consult someone who can draft a license contract for you. Do not focus on or concentrate on one particular issue only. It's natural to concentrate on all the financial aspects of a licensing or publishing contract. It's understandable, but I think, as we mentioned, provisions to do with remuneration are not the only ones that you should concentrate on. You should look into exclusivity, you should look into the term of your license, and also into the scope of your agreement, or into distribution channels. So there are many provisions that are tied to remuneration that you should consider. Thirdly, do not hurry up with signing a license. We do understand that obviously entering into negotiations either with a publisher or with any other contractor is not something that can be prolonged and dragged out and take years. We understand that there is a certain time frame to any negotiations, but to any signing, but you should not hurry into signing a contract. If possible, please consult someone with experience, someone who has signed or has negotiated licensing contracts before, or publishing contracts before. There are many organizations, foundations, and legal offices that offer free advice. So maybe it would be a good idea to take a breather, take a day off, and just consult with someone. And lastly, do not believe that if something is available and freely available, it does not come with terms and conditions, that it does not come with certain limitations. As explained in the beginning, if you are downloading photos from a stock of photos, if you are using Creative Commons, if you are using open source software, there are always terms and conditions, there are always provisions governing the use of that IP, and you should really read those and understand what you can do and what you cannot do.
Exactly, and it is linked with the first tip, what is general do's. So the first one is know your license, which means of course, you need to know whether there are any restrictions, what is the scope of use, what you can do, what you can't do, because otherwise, as in no doubt case, you can just breach the license and be exposed at legal risks. The next one is to do internal due diligence. So please check whether you are really authorized to, for example, give a license or to give further sub-license. Maybe you've got some internal rules that hinder you from giving a license. So check that before entering into contract. The next one is prepare for negotiations. So do some checking the internet, ask people, maybe ask friends, be prepared for negotiation, just know your contracting partner, gather information about him or her. And the last one, do a judge test. So read the license that you have, or that would the draft of the license, without any background. So put you in the shoes of the judge who does not know all the context, the background, did not hear telephone conversations with your telephone conversation with the other party, and so on, or just give the license to another person and try to, ask what she or he understands from the license, whether her understanding is the same as your understanding. And the last one, which is not included here, but is very important, just ask questions if you don't understand anything, to have the same interpretation of all provisions. Ask the other party what was the other party's interpretation and goal in that provision.
Okay, so we know that this was a very brief presentation of do's and don'ts of a licensing agreement. It was a crash course, let's call it. And you may have many questions, or you have particular aspects that are of interest to you. Unfortunately, we are barred by the time of this presentation. And if you have any questions, if you have any doubts, if you have any worries, please contact us, and we are available for a chat. We'll try to help. So contact us, drop us a line.
Thank you very much for being with us. See you.
Bye-bye. Bye.